You know, we've not. There's an application I'm making now. No, we are not yet. You know, the respondent wishes to make an application for him to be released on bail and reasonable bond terms. On the following basis, there has not been established any compelling reasons to warrant the respondent to be detained for 21 days. The respondent willingly submitted to the authorities when summoned. The respondent is a serving police officer. And the government has all the records. You know, you can discharge Jibril because we'll take long to make our submissions.
All right. So you are done with him?
We're done with it.
I think you can now leave.
Thank you.
Thank you. Thank you.
Yes.
You know, there has not been any material placed before this court to show an attempt to interfere with the investigations. My other brothers and sisters here will deal with authorities that demand for that. You know, this detention of 21 days is a plea detention. Where the liberty and the freedom of the respondent the purpose of bail and bond is to ensure the attendance of the respondent before this court. Is plea detention the only option available? To the state. You know, that has been dealt by, in the case of Oscar Sudi, by then Justice Professor Ngugi. My othership should deliver that authority and put the citations very clearly. The state cannot now say it cannot prevent interference with witnesses. The Republic of Kenya is not a banana country. That the state is scared of a citizen being out. The mandate, the government of Kenya, is to ensure everybody complies with the law. So the government cannot come to court that we fear he's going to interfere. That is a banana country that will tell people that we fear an individual is likely to interfere. If the respondent interferes, the bond terms will be cancelled and the state will come to court to show that he has failed to comply with the court orders. Your Honor, you are aware of the celebrated case of Michael Oyamo at the Court of Appeal, where the Court of Appeal was very emphatic that the court has jurisdiction, has power to impose conditions. And that is why we are seeking that the court imposes conditions of bail and bond. Your Honor, the fear of the state is a fear of a police constable. We urge the court to take judicial notice that people wielding massive powers in form of cabinet secretaries, sitting governors, heads of state at the ICC, when Kenyan leaders were taken to the ICC, they were released on bail. So that fear, Justice Kuril has dealt with that fear in the celebrated case of Dwight Sagare. The state must show by materials that the fear they are having is not mere apprehension. Then that this respondent can be released on cash bail, and the court orders he does not stay. He does not stay near Central Police Station. His parents are here, his relatives are here. He'll be confined to his home area until when the DPP decides to charge. Your Honor, we urge the court to stand firm and treat the respondent the same way all other accused people or respondents appear before you, so that it does not look that there is discrimination and there are two parallel laws for the mighty and for the constables. Your Honor, a mere statement that the police have a blue code of silence is not factual. It is a statement made to hoodwink the court. The applicant IPOA is seeking 21 days to detain the respondent in a police station not manned by IPOA staff, manned by the same police officers. At one hand, IPOA is confident with the police that remand him in police station. In the other hand, it is telling you, Your Honor, the police have a blue code of silence. You can't speak from both sides. Your Honor, this country, as citizens of this country, every government entity operates within its mandate. We urge the court to find that there are no compelling reasons. Your Honor, the Judiciary Handbook on bail and bond, which the court is very aware, has provided for parameters to be considered for denial for bail. None has been presented before you. The applicant says there is a public uproar. There are demonstrations on the streets. This matter has gone to the Senate. It has gone to the National Assembly. And the Commander-in-Chief of the Armed Forces, His Excellency, President Dr. William Ruto, has talked about it. It is our submissions that out of that, this is a knee-jerk reaction to show everybody and the people are talking that we have arrested someone. Your Honor, may you get favor in my submissions and allow the advocates with me to deal with the law and the authorities that will be supplying to court. I hope the state has been given those authorities. Thank you.
Right. Anybody else again?
Yes, Your Honor.
What's the name?
Stanley Kinyanjui.